Hello, everyone. So for this lecture, we're going to be going over jury deliberations. So what are the psychological issues that come into play as juries make their decisions? So most legal disputes are resolved without a jury trial, but there's still more than 150,000 jury trials conducted in the US every year. Approximately 2/3 of Americans have been called to jury duty, and approximately 1/4 have actually served as a member of a jury. Jurors and juries have been criticized. For example, civil juries tend to give more generous, shall we say, sometimes been called excessive monetary awards. Juries also have their defenders, so verdicts reached by representative juries can and often do increase the legitimacy of the process in the eyes of the public, particularly in those controversial trials. But are juries competent? Psychologists have examined factors that affect the accuracy of jury verdicts. We have learned that evidentiary strength is probably the most important determinant of jurors' verdicts, as well it should be, in both civil and criminal trials. But jury decisions can also be influenced by extra-legal information, irrelevant information about the defendant's background and or appearance, for example. So why are jury decisions influenced by this irrelevant information? So good old Calvin and Cecil that we talked about last lecture came up with what they called the liberation hypothesis. So when the evidence in a case clearly favors one side, juries will decide the case in favor of that side, maybe not surprisingly. But when the evidence becomes more ambiguous, jurors are liberated and allowed to rely on their own assumptions, sentiments, and biases, that extra legal evidence, in reaching their verdict. Now, what are the effects of that extra legal information? The mechanism by which juries reach these decisions is called dual process theory of attitude change, and this comes from Eagley and Shaken in 1993. And this distinguishes two different kinds of information processing strategies or routes. So the central is when the focus is on the evidence. But when the evidence is ambiguous or confusing in some way, then you have the peripheral, which is the focus on those extraneous details. There's also the influence of prior record evidence. Once jurors have heard evidence about a defendant's prior criminal record, they may be prejudiced by it and judge the current offense in light of the fact that they committed these past misdeeds. So the prosecution is often actually not permitted to introduce prior record evidence. But if defendants take the witness stand, then prosecutors may be able to question them about certain types of past convictions in order to impeach their credibility as witnesses. If the defendant takes the witness stand, the judge may issue what's called a limiting instruction, which is that evidence of a defendant's prior record can be used to engage the defendant's credibility, but not to prove the defendant's propensity to commit the criminal offense. Limiting instructions are actually rarely effective. Thus, attorneys often recommend that clients with prior records actually not take the witness stand to testify on their own behalf for that reason. In those scientific jury selection trial studies that we talked about, mock jurors informed of a defendant's prior conviction were more likely than jurors with no information about a prior record to convict the defendant on subsequent charges, although the similarity of charges was found to be an important variable. So, for example, your previous charge is petty theft, and this is a murder charge. It's going to be less important than if it was a previous murder charge. So there's an impact of evidence on multiple charges. So most courts permit a criminal defendant to be tried for 2 or more charges at the same time, as long as the offenses are similar or are connected to the same act. And this procedure is called a joinder. Researchers have found that defendants are more likely to be convicted of any single charge when it's tried in combination with other charges than when it's tried alone. So the idea is they gotta be guilty of something. And then there's the impact of character and propensity evidence. So historically, evidence about a defendant's character and propensity, evidence of other wrongdoing, could not be used in court. However, sex crimes are treated differently in federal court and in some states. Evidence of other sex offenses is admissible to show a defendant's propensity to commit the charged sex offense. And this is part of that risk assessment we've talked about before. If we let this person go, are they going to do it again? What effect might this propensity evidence have on jurors? Jurors likely will tend to make the fundamental attribution error we've talked about so much before. They've committed this crime before, therefore this is entirely due to something inside of them. Now, what about the impact of extra legal information in civil cases? So juries in civil cases usually make two fundamental decisions. The first is whether the defendant, or in some cases the plaintiff, is liable or responsible for the alleged harm, and whether the injured party, typically the plaintiff, should receive any money to compensate for his or her losses, and if so, in what amount. These monies are called damages. So, how do you determine liability? When psychologists study juries' liability judgments, they're really asking people to assign responsibility for that injury. Jurors should decide liability on the basis of the defendant's conduct. The severity of an injury or accident is irrelevant to the judgment concerning liability or legal responsibility. Do jurors determine liability correctly all the time? No, maybe not surprisingly. Why would we assign more responsibility to an individual as the consequence of his or her conduct became more serious? One explanation is this term defensive attribution, which comes from Fisk and Taylor in 1991. As the consequences of one's actions become more severe, we are more likely to blame a person for their occurrence because doing so makes the incident somehow more controllable and avoidable. Now, in terms of assessing damages in state civil court trials, in 2005, the median damage award was $28,000, and only 4% of winning plaintiffs received more than $1 million. 4%. I would imagine that a lot of you thought that that was much higher, right? In general, the more a plaintiff requests, the more a plaintiff receives. Jurors tend to adjust their awards towards anchor points, the most obvious of which is the plaintiff's requested damages. So, what factors do jurors consider in making their decisions about damages? As in criminal cases, jurors put the most weight on the evidence they hear in courts, as well they should. But sometimes they consider attorney's fees and whether any loss is covered by insurance, issues that are theoretically irrelevant to decisions about the amount of damages in award, but they still consider them. Now, inadmissible evidence is an important thing to think about here. So most of the evidence indicates that when a judge says this that was just said is inadmissible evidence, that's actually relatively ineffective. So jurors are more likely to comply with the judge's instruction to ignore inadmissible evidence if the judge gives a reason why that evidence is inadmissible. Instructions to ignore inadmissible evidence can backfire and actually result in jurors being more likely to focus on it. This is sort of a phenomenon we talk about in psychology, where if I tell you, like, don't think about a pink elephant, you're probably all thinking about a pink elephant right now, right? So sometimes it's like almost like reverse psychology or the power of suggestion. And jury deliberations can lessen the impact of inadmissible evidence. Now, what about expert testimony? We've talked about psychologists playing this role several times throughout the semester. So experts typically testify about scientific, technical, or other specialized knowledge about which jurors are not familiar. And there are some concerns with expert testimony. Because jurors lack rigorous analytical skills, they may use peripheral processing, so attention to superficial aspects of the expert's testimony. Did they look very professional? Did they use an effective PowerPoint? However, this particular concern has actually not been supported by research. Another concern is that expert testimony will mesmerize jurors. If you've seen the movie or the play Chicago, I always think of the courtroom scene in the song Razzle Dazzle, and cause them to discount their own common sense and rely too heavily on the opinions of the expert. And evidence does suggest that when prosecutors introduce expert testimony, convictions are more likely. And when experts testify on behalf of the defense, the likelihood of a conviction decreases. But is that because the experts are fancy, or is it because they're persuasive, right? Research suggests that jurors do not routinely defer to the experts' assessments. Judges who ultimately decide what expert evidence is admitted into court, back to that Daubert case we've talked about a lot throughout the semester, they can rely or allow unreliable expert testimony to be admitted into evidence just because the judge isn't an expert in everything either. So it can be sometimes difficult for them to determine what is actually scientific. So are jurors able to distinguish between reliable scientific evidence and quote-unquote junk science? No. In general, they can't. They can't distinguish valid from flawed research. And this, again, shouldn't surprise us if we think about the amount of well-supported science that's disputed by the public on a day-to-day basis. I'm thinking of things such as climate change. I'm thinking of things such as vaccination, which we talked about earlier in the semester. And I apologize, guys. I didn't realize I'm low on power, so I'm just going to plug in real quick here for y'all. Boom. All right, so we can keep going. So, can the jurors understand the instructions that they're given? Really, the greatest weakness for many juries is their inability to understand their instructions. The instructions are often full of legal terms that are unfamiliar to lay people, and jurors may or may not be provided with a written copy of their instructions, and they're almost never allowed to ask questions in the courtroom to clarify any misunderstandings they may have about the law. Psychologists have been able to simplify jury instructions, and those have been shown to be easier to understand by jurors. Although those in the legal system have generally not been receptive to reforms suggested by psychologists and other social scientists, some have recently revised positions of their jury instructions. So the state of California is an example here. Although instructions are typically read just before the jury retires to deliberate, some states now require judges to provide preliminary instructions before the evidence is presented. Instructing the jury at the conclusion of the trial reflects a belief in the recency effect, which is that recent events are generally remembered better than remote ones. The idea that jurors should be instructed before the presentation of testimony because it gives them a mental framework to appreciate the relevance or irrelevance of testimony as it unfolds rests on the notion of the primacy effect, that the instructions will be most beneficial effect if they're presented first. And one thing I realize I skimmed over here that's really important is that research has shown that if these instructions are written, it's often much more effective as well. So Foster, Lee, and Horowitz in 2003 reported that mock jurors who received instructions at the beginning of the trial recalled and used more of the evidence than did jurors who were instructed after the evidence. So there's some evidence here for the use of the primacy effect. Jurors who received pretrial instructions said that they were able to focus better during the trial as well. And judges also believe that substantive preliminary instructions help jurors to follow the evidence. So judges are often on board with this. Juries have the power to acquit defendants despite evidence and judicial instructions to the contrary, even though they often don't know that they have this power. This power is termed jury nullification and has permitted jurors to acquit defendants who were legally guilty but morally upright. Just sort of questionable. So how would juries behave if they were informed they had the option to disregard the law? So data from another study by Horowitz and colleagues in 2006 showed that jurors tend to rely on their feelings and sentiments and to nullify the law only when the law itself seems unfair. Now, can jurors decide more complex cases? Complex civil cases often require the jury to render decisions on causation, liability, and damages for multiple plaintiffs, multiple defendants, or both. Think about like class action lawsuits, for example. In criminal cases, the use of forensic evidence, such as DNA evidence, contributes greatly to case complexity. Many arguments have been made against the use of juries in these complex cases. So the arguments are that the evidence is too difficult for a layperson to understand. The general information load on juries is excessive because of the large number of witnesses. And that less capable jurors are left to decide due to voir dire, that we've perhaps excused jurors who are familiar with the case or more competent in some way. And the complexity of the trial does impact jurors. So again, our expert here, Horowitz and colleagues back in 1996, found that complex language lessened jurors' ability to compensate plaintiffs who suffered injuries of varying severity. So really, attorneys and witnesses should think about the complexity of their language, which is really interesting. Overall, the findings point to the need for attention to how complex a case is presented to the jury. So giving the jurors opportunity to take notes, for example, might be a nice solution. Are juries biased? This becomes a really important opinion decision to think about, right? So there's the blank slate assumption that courts assume that jurors can put aside any preconceptions about defendant guilt or the merits of civil defendants and plaintiffs when forming their judgments. Is a fair and unbiased jury an impossible ideal? Maybe. Attorneys are motivated to select jurors who are favorable to their own side, and it is impossible for anyone to be completely uninfluenced by past experiences and resulting prejudices, as we've seen with some of what we've talked about with even judges, for example. Juror bias is a juror's predisposition to interpret and understand information based on past experience. Personal predispositions may affect views towards the prosecution or the defense, or both, and may affect the way that the evidence is evaluated. Jurors may show pre-decisional distortion, distorting the evaluation of the evidence to support their verdict choice. Do jurors' biases predispose them to favor one side over the other in a civil case? Although elements of sympathy do play some role in deliberations, as do feelings of anger toward a defendant, the general public has been found to be, this is a quote, quite suspicious of and sometimes downright hostile to civil plaintiffs. We have this idea that people just sue to sue, right? When in fact that might not be the case. Do juries give larger awards when a defendant is wealthy? Jury damage awards are consistently higher in products liability and medical malpractice cases than in, for example, automobile negligence cases. It appears that any inflation of awards against corporate defendants is apparently related to their status as a corporation and not to their wealth. So corporations are held to higher standard of responsibility than individuals. And how do jurors make sense of the evidence they hear during the trial? Jurors construct stories about the evidence so that it makes sense to them. This is a natural human tendency. We like things in a narrative. And in the process, they pay attention to certain pieces of evidence while possibly ignoring others. Hastie and Pennington developed the story model to describe inferences that individual jurors make when reaching a decision in a case. Now, how could we reform juries, right? This becomes an important question. So some reforms have been fairly uncontroversial. So listing witnesses and summarizing their testimony in longer, complex cases, giving pre-instructions or interim instructions during a lengthy trial, allowing jurors to take notes, designating alternate jurors only after the trial so that everyone thinks they could be on or they could be an alternate, giving a written copy of the judge's instructions, and allowing jurors to examine the demonstrative evidence during their deliberations. And when you watch 12 Angry Men after this, you'll actually see that. Two reforms have been more radical. One is allowing jurors to pose questions to witnesses. The questions would be screened by the judge, who would decide whether or not they were appropriate. And jurors questioned about the opportunity to submit written questions have been very supportive of that possible innovation. And then the last possible reform that's more radical is allowing jurors to discuss the evidence in the midst of the trial. Most judges tested indicated that they actually support this. About half the attorneys and litigated tested thought that the trial discussions improved juror understanding of the evidence, although the other half agreed that trial discussions might encourage premature decision-making. jurors who have reported having these discussions were really quite positive about them. So something to think about. All right, so that is our discussion of juries. I look forward to reading your assignments and seeing what you think about 12 Angry Men. It's actually my husband's favorite film, and I think it's done quite well. To set it up just a smidge more, you should know that it's based on a stage play. And so some occasionally of the way that the blocking or how the actors move seems a little unnatural because it was originally done for the stage, but it's quite well done, and I hope that you enjoy it.